Hello everybody, we are the business law subject students. So today we're gonna present about our project. Our title is the industrial code. We're gonna learn about the industrial code. My name is Lachlan Lee.
And my name is Muhammad Hakimi bin Suhaimi.
And my name is Ng Chun Yin.
Okay, let's go to the presentation. Hi everyone, so today we're gonna present about the industrial code of Malaysia. It's also known as Mahkamah Perusahaan Malaysia at KL. So today we're going to present and make sure you all understand. We will present in very detail. Make sure pay attention. Let's go to the next slide. Hello everyone. So we're going to talk about the introduction of the principle of law. The first thing we need to know is the Malaysian legal system. It's a very important thing. So before going into the history and background of the industrial code, it is important to know that Malaysian legal system is understanding and the role for the industrial code to understand it better. And the next thing we need to know that we're going to show about the diagram of the hierarchy of industrial code. Okay, let's go. Okay, this is the diagram of the Malaysian legal system. So we all know the first thing, the biggest is the federal code. The second is the court of appeal. Court of appeal have two sections. One is the High Court Malaya. After that we have the section court, then we have the magistrate court. For second one is the High Court in Sabah and Sarawak, also known as Borneo. After that we have the session court, also have magistrate court. Most of the time we want to appeal a case, most of the time we go from below to the top. Okay guys, for the next slide, in the Malaysian legal system, the court structure is very influenced by the English court system, a legacy from colonial period, also we known as the British Army or British government. So the court is divided into subordinate court also and the superior court. The superior court are the High Court, Court of Appeal and Federal Court, which is the highest court in Malaysia. So the subordinate court comprise the section court, magistrate court and the penghulu court. In the additional, this court are the others court established for specific purpose and under specific statute. Among them, the labor court, the Sharia court and the tribunal consumer claims and the industrial court, which is our topic today. So the industrial court is the most important in terms of substantive adjudication as well the number of cases. The source is from Sharia Swan Ahmad 1999. So the industrial court is established under Section 21, the Industrial Relation Act 1967, and here's case related to unfair dismissal of workmen and trade dispute. So it's basically industrial court is basically the case about the company fire you without any legal reason. So this is the main case and main court you can go. The decision of the court, which is known as the award, is final and conclusive. It can only be reviewed, appealed or quashed by the High Court on the ground and general of natural of justice, or if the industrial court has acted in excess of jurisdiction of the instated Industrial Relation Law Act 1967. So the next position, the position of the industrial court is known as in the following diagram, which is the next slide. Okay, this is the second diagram in our presentation, which is the position of industrial court in Malaysian legal system. So the industrial court is a different section that straightly go into the High Court of Malaya. Also, we'll go to the High Court of Sabah and Sarawak. Okay, the next slide we're going to talk about the history and the background of the industrial court. Unlike the ordinary law court, the industrial court is a specialized body that has established for a purpose. The main purpose is to educate on the matters relating to the trade dispute. The industrial court as a first established in 1940 under the Industrial Court of Inquiry laws. However, it did not deal to the function of the Japanese occupation in Malaysia when the Japanese conquer Malaysia. But in the 1948, it started back. The Industrial Court Ordinance was introduced, which allowed a tribunal to hear distribute the request of the parties involved. It was a voluntary administration body between 1998 to 1968. Only 4 disputes were heard. This is because the award decision handed by the court were not legally binding, and therefore the court was limited to their effectiveness. This voluntary arbitration system was later amended with the introduction of the Industrial Arbitration Tribunal 1965. This tribunal deals with the dispute in the certain essential service which prohibits any industrial action with the industrial sector which are classified as essential service. Thus, exists a dual system, volunteer arbitration and compulsory arbitration at the same time. When the two systems existing side by side, the government found a compulsory arbitration to very effective method reducing the incidence of strike. In 1967, the enactment of the Industrial Relation Act 1967, the concept of the compulsory arbitration was introduced. Any industrial dispute was not settled through the mediation of the complication of the provided in the Act would be referred to the Industrial Court for arbitration. The present Industrial Court is instituted under the Industrial Relation Act 1967. The Act has been amended several times in 1969, 1971, 1975, 1976, 1977, and also 1980, and in also 1990. However, all these amendments did not offend the existing basic provision, that is, an act is provide the regulation of the relation between employer and workman and their trade unions and the prevention of the settlement any difference and dispute arising from their relationship, and generally deal with the trade dispute and matter arising therefrom. Industrial Relation Act 1967. The objective and the roles of the Industrial Court. The main objective of the Industrial Court is to settle trade dispute. It is provide to a peaceful and unbiased means of settling dispute between employers and employees when each other method to resolve the dispute have failed. See Driving 3. Driving 3 is about the various stages in settling trade dispute. Matters start after IRO tries to concede between the employer and the employee, which is the union will start the strike. The IRO failed to settle the dispute. It refers to matter to the DG for the industrial relation. This problem starts when the union cannot solve a problem with the employer, so they wanna seek help from the DG for the industrial relation. So the next thing, the DG again may try to conciliate. So the DG fails to settle the dispute. He reserves the dispute to the Minister Law of Labour. So the minister may take the necessary step to make conciliate. But if the minister fails to settle the dispute, he may receive the dispute to the IC for arbitration, which is the Industrial Court. So after the union go to the Industrial Court, the Industrial Court arbitrates and hands down on an award. So either party dispute unhappy with any term of award, we may appeal to the Industrial Court for permission to refer points or question of law of High Court for a decision. If this appeal is granted for the matter of go to the High Court will hands out its decision. Further appeal may be made by the Court of Appeal. If the court is still not solved, it will go to the Court of Appeal. If still cannot go to the Court of Appeal, it will go to the final appeal made by the Federal Court, which is High Court in Malaysia.
Okay, next slide is a trade dispute arises between the employer and the employee union. A trade dispute means any dispute between any employer and his workman which is connected with the employment and non-employment or the term of employment of or the condition of work of any such workman. Next, the Industrial Court also set up principles and guidelines for labor laws or the parties involved in industrial relation practice. Through its decision and award, it has set presenting that are to be followed in the practice of the labor law and the industrial relation system. Aside from setting important principles and guidelines, the court is to issue decision or grant awards arising from industrial dispute speedily and economically. Taking into consideration the public interest, the financial implication, and the effect of each such award on the economy of the country and on the industry concerned, and also to the probable effect in related or similar industry. Finally, other important rules of the industrial court is to register and give cognizance to collective agreement. Collective agreement deposit with it are checked to see that they fulfill all the legal requirements and are enforceable under the law. This is to ensure that the worker rights are provided and protected so that a harmonious industrial environment could be created and maintained in line with nation industrialization and investment policy of the country. Okay, the next slide is about structure and proceeding of the industrial court. The industrial court is headed by the president. He is appointed by the Yang Dipertuan Agong, the king, and has a number of chairmen to assist him. The president is responsible for the whole function and activities of the court. Under the Industrial Regulation Act, the president is required to have at least 7 years of experience as a lawyer before his appointment, or he must be a member of the judicial service. There is a total of 30 chairmen for the industrial court, with 21 chairmen in Kuala Lumpur, 2 in Penang, 2 in Perak, and 2 each in Sarawak and Sabah, and 1 in Terengganu. The latest branch edition of the industrial court. Let's see the diagram 3. Okay, the next is organization chart of the Industrial Court of Malaysia. The Honorable President of the Industrial Court have divided 3. The first one is Court Chairman is in Kuala Lumpur. The second one is Court Chairman Branch, which in Pulau Pinang, Perak, Johor, Sabah, Sarawak, and Terengganu. The last one is Registrar, and the next is Assistant Registrar, and the Assistant Registrar has divided 3: General Administration Division, Case Registration Division, Collective Agreement Division. Okay, the source you can visit here. Okay, the next slide is the proceeding of the court are similar to a court of a law but less formal. Next, for cases of trade dispute, the hearing will consist of the president and 2-member panel. 1 person representing employers and 1 person representing employees. However, if it was a case of unfair dismissal, the president or chairman can sit alone without a panel. Next, the proceeding of the industrial court is similar to any court of law. Once a pleading is called for a hearing at the court, a party to any dispute may choose to represent himself or be represented by any official of a trade union or a union of employers. In the case of the employers, he may choose one of his officers to represent the company. If the company is a member of a trade union of employers, the company can be represented by an officer or an employee of the union. Next, the company can also be represented by any official of the Malaysian Employers Federation (MEF). In the case of the employer, he or she may choose to represent himself or herself or be represented by an official or employer of the Malaysia Trade Union Congress (MTUC). Next, for the union, they can appoint an officer or an employee of the union or an official of the MTUC to represent them at the hearing. If any of these parties is to be represented by a lawyer, permission of must be obtained from the president or chairman of the court. The table shown in illustrates the representation of parties at the industrial court hearing. The next slide is the representation of parties at the industrial court hearing. The employer is company officer, and then the employee by himself, and the union by union officer of employee. Okay, the next, employers, the employers association officer, employee by MTUC or union official. Union is by MTUC official or employer. Okay, the next one is employers is the MEF official. Employee is by lawyer. Union is by lawyer. And the employers also by the lawyer. Okay, the next slide is once a dispute is referred to the industrial court, no industrial action such as a strike can take place. The court has the power to call on witness and document when necessary for the hearing. Okay, the next, before the hearing, the parties to a dispute are required to submit a written summary of their agreement. Next, these are called pleading. The pleading are important because when the court makes its decision, it will only consider whatever is asked and include in this pleading. Other matter brought up during the court hearing but not in the pleading will normally not be considered. Okay, next, during the hearing of the dispute, each party is given the opportunity to present his or her case, and the event leading to the dispute, witness and document can be present to support and prove their case. Next, each party can cross-examine the other witness. The court president or the chairman may also ask questions from both parties from time to time. Once all agreements are presented and complete, the court will adjourn. Next, it will make its decision which will be written up and it called an award. An expert hearing is sometimes held when one of the parties to a dispute does not turn up in court. If the court is satisfied that the party concerned was already aware of the date of the court hearing, the case will be heard without the party present. In the case of unfair dismissal, it is important that both parties attend the hearing. If one of the party does not turn up, the advantage is on the party who is present. The party present will usually win the case as there is no one to rebut the agreement and evidence offered. The next slide is about award of the court. The decision handed down by the court is referred to as an award. It is legally binding on the parties involved and cannot be challenged or appealed. Once an award granted, it is final. Section 33 of the Industrial Relations Act states that the award of the industrial court shall be final and conclusive, and no such decision shall be challenged, appeal against, reviewed, queried, or called in question in any court or before any other authority, judicial or otherwise, whatever. However, if a party is dissatisfied and questions of law are raised, the High Court in exercising its supervisory function may reveal an award on the ground of denial of natural justice or whether the court was getting the access of its jurisdiction. Thus, even though the decision of the industrial court is final and binding, it is possible for an party who is dissatisfied with the industrial court decision to file for a right or certiorari an order of the court to quash or annul an industrial court award. A high court decision can then be appealed again in the Court of Appeals and the Federal Court. In this higher level court, it does not hear the case, but this is whether the industrial court had jurisdiction to hear the case and make an award, and if it did, whether it had properly applied the law. The next slide is jurisdiction of the court. The industrial court deals with 4 types of case and is also responsible for giving of cognizance to collective agreements. The 4 types of case handled by the industrial court are unfair dismissal of and retrenchment. Next, trade dispute, interpretation of collective agreement or award. Last, complaint of non-complaints. Cases of complaint of non-complaints and interpretation of collective agreement or awards are brought to the industrial court through direct reference to the court, whereas court cases of unfair dismissal and trade dispute are brought to the court through the recommendation of the Minister of Human Resources. Okay, let's see the diagram 4. Okay, the diagram 5 is reference of cases to the industrial court. Unfair dismissal and the trade dispute handled by the minister. When the minister cannot handle, will be handled by industrial court. The special case is complaint of non-complaint or interpretation of variation of collective agreement or award will also handled by the industrial court.
Okay, so now I will talk about unfair dismissal claims, which is Ang Chun Yin talk in the diagram. So the first thing is dismissal cases make up the most of the court's cases. So an employee who has been dismissed from work can file a complaint of unfair dismissal and request for reinstatement with the Director General of Industrial Relations within 60 days of his dismissal. So usually claims of unfair dismissal are settled by conciliation, but if the Director General of Industrial Relations is unable to reach a settlement, the dispute will be referred to the Minister. The minister who has been notified will refer the case to the industrial court. The court's power in respect of unfair dismissal. Upon receiving a complaint of unfair dismissal, the court will decide whether or not the dismissal was without just cause and excuse, or whether the employee was properly and fairly dismissed. If the court is satisfied that employer has followed the proper procedures for dismissal and the employee deserves to be dismissed, the court will uphold the dismissal. However, if the court finds that dismissal was unfair, the court can make an order for the reinstatement of the employee. The employee will be given his job back with all the benefits he had at the time of his dismissal. In most dismissal cases, reinstatement is relatively rare. This is because by the time the dispute is settled, a 2-year period has elapsed. By that time, the employee would usually have found another job. Sometimes, reinstatement is also not the best solution because the relationships between the employee and the employer have become too strained during the course of dispute. In this case, the court will usually award the employee compensation. The company will pay the employee compensation in lieu of reinstatement and back wage. This is usually calculated from the date dismissal to the last day of hearing up to a maximum of 2 years and 1 month's wage for every year of service. However, if the employee has been gainfully employed elsewhere, the court may reduce the amount of compensation accordingly. Unfair dismissal and retrenchment. In the mid-1980s, termination of service due to redundancy was quite common. Even though retrenchment is a management prerogative, it can cause a dispute if the employee has been unfairly dismissed. An employee can file a complaint under Section 20 of the Industrial Relations Act for a reinstatement if he thinks he has been unfairly dismissed. The court, on receiving this case, has to first determine whether the retrenchment was the real reason for termination and whether it was justified and procedurally fair. If the employee can justify the retrenchment exercise and the court is satisfied, the right of the employer is retrenching his workers is no longer questioned. To trade disputes, Industrial Relations Act 1967 states that trade dispute is any dispute between an employer and his worker and his workman which is connected with the employment or non-employment or the terms of employment or conditions of works of any such workman. When other methods of settling a trade dispute have failed, the case is usually referred to the industrial court. This is done by reference from the minister or at the request and in writing of both disputing parties. Cases of this nature are usually a dispute where an individual worker has a grievance against his employer and he is represented by his union. Most of these cases are claims of unfair dismissal, although there are also cases where a worker claims that unfair disciplinary action has been taken against him by the employer. Another case of trade dispute handled by the court is a dispute over terms of conditions of service or collective bargaining. A union representing the workers in a particular company is not in agreement with the employer over some terms and conditions of service. The court handles this dispute when other methods of conciliation have failed. Interpretation of collective agreements or awards. This case can be brought directly to the court by the parties concerned. The court's responsibility is to interpret any part of the collective agreement or award which is disputed by the party. Parties may have come to an agreement over the meaning of a particular clause or section in the collective agreement or award during the time, but at the time of implementation, this agreement over interpretation may arise. Thus, the court should decide on the correct interpretation of the particular clause or section and the way it should be implemented. Complaints of non-compliance. Complaints of non-compliance with a collective agreement or a court award can also be brought directly to the court. A union or the personnel bound by the award or agreement may lodge a complaint to the court if any term of the award or of the collective agreement which has been taken cognizance of by the court has not been complied with in writing. The court, upon receiving the complaints, may order the company which fails to comply with the court award or collective agreement to do so. Reason of collective agreement. The final jurisdiction of the court is to grant cognizance to collective agreements. All collective agreements must be signed and deposited with the court. The court will check that they fulfill all the legal requirements and are not contrary to the law to render them invalid. It is then accepted by the court and are thus enforceable by it. The court also has the power to require the signatory parties to amend any parts of the agreement where necessary. Okay. The function of the Human Resource Department. In any work organization, the Human Resources Department is the backbone of the organization. Known in the old days as the Personnel Department, it is now called the Human Resource Department. The change to Human Resource Department is not just a cosmetic change. According to Kinnicky and Williams, 2006, the change is intended to suggest the importance of staffing to a company's success. The Resource Department is responsible for planning, attracting, developing, and retaining an effective workforce. The human resource has to consider the overall company strategy, how to evaluate current and future employee needs, and how to recruit and select qualified people. Human resource management includes orientation, training, and development, how to assess employee performance and give feedback. The most important of all its function is Human Resource Department must consider how to manage compensation and benefits, promotions and discipline, and workplace performance problem. In managing an effective workforce, Human Resource Department must oversee as well and as also solve organization problems like poor performance and dismissal. In carrying out these duties effectively, Human Resource Management need to know the legal rights of the employer and also the employees and the laws concerning industrial relations. In summary, the function of the Human Resource Management is to get optimum work performance that will help realize companies' vision and mission. Legal issues are so central to all human resource activity. Proficient and able human resource managers are therefore vital in running and managing the Human Resource Department effectively. Thus, IR as a source of reference and information is essential in helping the human resource management, whose role in gradually becoming broader and broader with globalization. Overview or outline of the thesis. There are 7 chapters in thesis, and each chapter and its content are described briefly below. Chapter 1 begins with an introduction to the study, followed by the objective of the study and the research questions. The importance of industrial law reports is mentioned and why a general-based study is important in studying the industrial law reports. Since the focus of this study is on dismissal cases of the industrial court, a brief background of the Malaysian legal system is presented and included before the rules and functions of the industrial court are discussed. The chapter ends with a brief discussion of the function of the human resource management, in particular its role in handling disputes at the workplace. Chapter 2 provides a review of literature relevant to the research undertaken. The review discusses the the three approach to the general analysis, namely the English for specific purpose theory, the Australian educational linguistic theory, and the North American new rhetoric theory. Chapter 3 focuses on the review of the literature on legal discourse. Studies on legal discourse are discussed in this chapter. This review attempts to show that the lack of research on legal general in Malaysia warrants the current study to be undertaken. Chapter 4 describes the methodology used in this study. Data collections, choice of genre and methods of analysis are discussed in this chapter. Bhattia's move analysis, which is akin to that of Swales, was found to be the most suitable and is used as a guide in this study. The main analysis of this study will be in Chapter 5 and Chapter 6 respectively. Chapter 5 focuses on the move analysis of this study. The results and the finding of the moves analysis are discussed in this chapter, and a model of the structure of the industrial law report is represented. Chapter 6 presents some of the salient linguistic features found in the dismissal cases of the ILR. Although the ILR is not as a legalist as other law cases, the linguistic realizations which appear to be pertinent to this genre are highlighted and discussed in this section. Chapter 7, which is the final chapter, discusses the findings of the study. All the research questions are dealt with and discussed in this chapter. This chapter also highlights the conclusion and implication of this study. It ends with further suggestion and recommendation for future works in this area.
Okay guys, now I'm going to talk about the relevant cases to the industrial court. So the first case I'm going to talk about is the Hotel Incorporated MSDNBHD v National Union of Hotel, Bar and Restaurant Workers, happened in 1984 1 MLJ 363. So the case is what is about. The industrial court has made the award binding the both parties, but the hotel has applied the question of law referred to the High Court, and this was dismissed by the industrial court. Then so the hotel has took the matter to the High Court, and the High Court has allowed the application on certain question, but the dismissal one of them. The Federal Court has heard the appeal in the respect of the dismissal and decided to be quashed the decision that made in the industrial court. On the ground, the industrial court has wrongly dismissed the application and acted in excess of the judicial when the additional will indicate with the question there is no power to do so. So what this case is happening is the hotel has take this case to the industrial court, but the industrial court was not given a correct award. So the hotel management has take this case to the High Court. Then from the High Court it will go to the Federal Court, and the Federal Court was given the correct award, the correct judgment, and the judgment was prevailed. Okay, the second case is the Superior Malaysia SDNBHD v Muhammad Lazi bin Katan 1989 3 MLJ 243. So this case was the respondent was dismissed for misconduct. It was claimed under the section 69(1) of the Employment Act 1955 for the several wages. A labour officer conducted an inquiry and that made an order for the employment to pay sum of money to the respondent in complement with an award of the industrial court, but the High Court in regards to this matter had decided to the Labour Hospital has no discretion to determine the claim to be involved the interpretation of complaints with the award of the collective agreement. Okay guys, so the conclusion of our industrial court is simply all about the industrial court. The chapter has provided the background of the study and the objective of the rational studying industrial law response reports and the reason for the importance of the conducting general based study. A brief introduction to the Malaysian legal system has been discussed to understand the position and the role of the industrial court. So seeing the dismissal of the case of the industrial court is in the focus of the study, the roles, the composition, jurisdiction and the powers of the industrial court have also has been discussed. A section in the human resources HR management function is also included as the HR is so central in the dealing with the workers, dispute and cases in the work organization before they are taken up to the industrial court. Okay guys, that's all is about our presentation. This is our end of the presentation.
Hope you guys can learn something from our video.
If you have done any mistake during this presentation, hope you guys can correct us. So, thank you.
Thank you.
Thank you.